Welcome to the eighth in this series of presentations that have been developed as part of the Plymouth College of Art and Atlantic Youth Creative Hub's Creative Entrepreneurs Business Incubation Programme. This programme was designed to support young creative entrepreneurs by providing the fundamental skills required to develop an idea, plan and start a business, and ultimately take their products or services to market. Through a series of workshops, events, and mentoring, participants increase their business knowledge, gain confidence to start a new business, and develop their professional practice. My name is Mark Cotton, and I've produced this series of presentations to capture and share the content of the AYCH workshops, creating a resource for future reference. If you want to set up a business that has social, environmental, or community-focused objectives, there are a number of options open to you. In this session, we will explore the different types of legal structures available to you as a social enterprise. As we've discussed previously, social enterprise in itself is not a legally defined term or status. It's not a legal structure in its own right, and there may be subtly different views on what actually constitutes such an organisation. It is commonly accepted, however, that a social enterprise is a business trading in goods or services which has the following key features. Its objectives are primarily have a social and or environmental benefit, as opposed to maximizing profits for shareholders and other investors. And at least the majority of surpluses or profits are reinvested or retained to further the organization's social and community objectives. There is scope for social enterprise structures to take different forms, ranging from the relatively formal and simple to the highly formal and sophisticated. And this includes incorporated and unincorporated structures, and potentially having charity status. You must choose a business structure or a legal form of some shape if you're starting a business, even if you plan to just work on your own and not formalize anything. So if you want to set up a business that has social, charitable, or community-based objectives, then generally you can set up as any one of the following: a limited company, a charity, a charitable incorporated organization or a CIO, a cooperative, a community interest company or CIC, a sole trader, or a business partnership. And I'll talk about these in more detail later on. But first, let's take a look at the key considerations when selecting a structure. Firstly, you'll need to consider how the liabilities and obligations of the business are managed and whether it makes sense to seek limited liability status in respect of any liabilities that arise from the operation of the organization, and whether to choose an incorporated or unincorporated structure. You need to consider whether the entire membership of the organisation will have a role in managing the business on a day-to-day basis, or whether there should be a separate governance board. You'll need to consider how wide the organisation's membership should be and how accountable the organisation should be to both its membership and to external stakeholders. You'll also need to think about how the organisation intends to direct the profits from its enterprise, for example, to members or back into the organisation to further its goals. And consider whether charity status is appropriate and worthwhile, or whether more tax transparent structures such as partnerships or limited liability partnerships are more appropriate. Consider the varying costs associated with different structures and how startup costs will be covered generally, and weigh up the various factors relevant to different business structures, both at their inception and on an ongoing basis. So as I said, legal form means the type of structure an organisation takes in the eyes of the law. And each legal form has legal restrictions and advantages depending on your organisation's purpose and intentions. In addition to the key considerations just mentioned, there are a few important things to understand before deciding what legal form or structure is right for you. Legal forms can be either incorporated or unincorporated. Incorporation means creating a legal identity for an organisation that is separate from its members, so a corporate body. An incorporated form exists in its own right and can enter into contracts and own property in its own name and employ people. Incorporated organisations can meet their liabilities from their own assets and will limit the liability of individual members. In this way, organisations that have a moderate to high level of risk may decide to incorporate to protect their members in the future. An unincorporated organisation has no separate legal identity of its own. What that means is that those individuals enter into obligations such as contracts, on behalf of their organisation, and they are then responsible for debts and other liabilities. The central feature of most unincorporated businesses or organisations is personal liability for the owner, partner, or member of the management committee. So if you're on the management committee of an unincorporated association, your personal assets are at risk if the assets of the organisation are not sufficient to cover all the debts and liabilities. A charity is a specific type of organisation and must conform to the regulations set out in charity law, particularly the Charities Act of 2011. And charity status is a legal status for an organisation, not a legal form or structure in its own right, and charity status is additional to the basic legal form. Some legal forms and organisational types, for example, community interest company and cooperatives, are incapable of being charities because they're designed to provide non-charitable benefits. For example, members or shareholders may be automatically entitled to certain payments or distribution of profit. And charities are not owned by anybody. The charity is controlled and its assets are held in trust by a board of trustees who are responsible in law for ensuring that charities are well run and deliver their charitable purposes for the public benefit as set out in their constitution. So what about sole traders? If you're a sole trader, you run your own business as an individual and you're self-employed, and the sole trader model has no separate corporate identity. What this means is you can keep all your business's profits after you've paid tax on them, but you're personally responsible for any losses that your business makes. You need to set up as a sole trader if any of the following apply. You've earned more than £1,000 from self-employment in the financial year. This is up to the 5th of April 2020. And you need to prove you're self-employed, for example, to claim tax-free childcare. Or you want to make voluntary Class 2 national insurance payments to help you qualify for benefits in future years. To set up as a sole trader, you need to tell HMRC that you pay tax through self-assessment, and you'll need to file a tax return every year. You'll also need to do other things, such as keep records of your business's sales and expenses. You need to pay income tax on your profits and Class 2 and Class 4 national insurance. And you must register for VAT. You must register for VAT if your turnover is over £85,000. You can register voluntarily if it suits your business, for example, if you sell to other VAT registered businesses and want to reclaim your VAT. You must also follow certain rules on running and naming your business. You can trade under your own name or you can choose another name for your business. But as a sole trader, you must not use things like limited or limited liability partnership or public limited company or PLC in any of your company names. On the pro side, it's cheap and easy to set up and can be run with relative informality. You do not require formal accounts to be prepared. On the downside, there's a lack of a distinct legal identity for organisations to deal with, which can cause problems for some contracts and commissions. And you have sole personal liability if things go wrong. A limited company, on the other hand, is typically a company limited by shares or limited by guarantee. And limited by shares companies are usually businesses that make a profit. This means the company is legally separate from the people who run it, has separate finances from your personal ones, has shares and shareholders, and can keep any profits it makes after paying tax. It's typically a two-tier structure with shareholders and directors manage the day-to-day operation of the company on behalf of the shareholders. And you can be a director as well as a shareholder. On the plus side, incorporation is relatively quick. The liability of members is limited to their capital contribution. It's a widely used and commonly understood structure. On the downside, it's not commonly associated with not-for-profit organisations and can present more stringent filing requirements and general regulation than compared with some other structures, such as sole trader. Limited by guarantee companies are usually not-for-profit. This means that the company is legally separate from the people who run it, has separate finances from your personal ones, but has guarantors and a guaranteed amount, and invests profits it makes back into the company rather than paying dividends to shareholders. On the plus side, the liability of members is limited to a specified amount in the guarantee, commonly associated with not-for-profit organisations, suitable for any size of organisation, enabling a small organisation to expand without restriction. On the downside, it's not usually adopted as a vehicle for commercial entities or with a view to generating profit for investors. It's subject to the same stringent filing obligations as a company limited by shares, and it's unlikely that you are able to raise finance through the issue of shares because there are no shareholdings within a company limited by guarantee. A community interest company, or a KIC, is a special type of limited company which exists to benefit the community rather than private shareholders. KICs can be limited by shares or by guarantee, similar to limited companies, although there are strict guidelines on shareholdings and also a cap on any dividends paid out. A KIC must include a community interest statement, explaining what the business plans to do for the community and setting out its social or environmental objectives. It must also include an asset lock, a legal promise stating that the company's assets will only be used for its social or environmental objectives, and if a KIC is limited by shares, setting the limits to the money it can pay to shareholders. A KIC needs to be registered on Companies House in the same way that a standard limited company is, but also approved by the Community Interest Company regulator. On the plus side, this is a structure which is designed as a vehicle for social enterprises to use profits and assets for the public good and offer limited liability. In addition, it's based on the familiar corporate structure, but with added supervision by the KIC regulator. On the downside, KICs can only make limited financial returns to investors, and surplus assets on cessation will be preserved for its community rather than be distributed to members. So the restriction on the organisation making a financial return for shareholders could inhibit external investment. So what about a charitable incorporated organisation, or a CIO? Some charity structures are corporate bodies, and this gives them the powers to employ paid staff, deliver charitable services under contractual agreements, enter into commercial contracts in its own name, and own freehold or leasehold land or other property. And if a charity structure is a corporate body, generally its trustees aren't personally liable for what it does. On the plus side, CIOs, as a charitable entity, are generally exempt from corporation tax, where the profits of its charitable trade are applied solely for the purposes of the charitable entity. Members and trustees are usually personally safeguarded from the financial liability the charity incurs. On the downside, however, generally speaking, staff members cannot be trustees. Therefore, if you're an owner-operator, you will either lose control or you'll have to move away from having an active paid or employed role in the organisation. Unincorporated organisations. So if a charity isn't a corporate body, so it's unincorporated, then the trustees are personally liable for what it does. It won't be able to enter into contracts or control some investments in its own name. Two or more trustees, a corporate custodian trustee, or the charity's landholding service will have to hold any land on the charity's behalf. On the plus side, it's cheap and easy to set up and can be run with relative informality. Unincorporated associations are not generally subject to outside legal control. On the downside, the lack of a distinct legal identity for organisations to deal with often poses problems. It's more generally suited for organisations with small membership. For an unincorporated association, a change to its rules requires unanimous agreement, which can sometimes be unworkable if you have large groups of members. And then a simple business partnership. In a partnership, you and your partner or partners personally share responsibility for your business. This includes any losses your business makes, bills for things you buy for your business, such as stock or equipment, and partners share the business's profits, and each partner pays tax on their share. A simple partnership has no legal personality separate from its partners. It therefore cannot own assets or grant security over them. However, Court rules now permit partnerships to be sued and to sue in the partnership name. Partners are jointly liable for the contractual debts and obligation of the partnership. And partners are also jointly liable for the wrongful acts or omissions of their fellow partners. Hopefully that's given you an overview of legal forms and structures for you to consider when setting up a social enterprise. Obviously, you'll need to seek more advice on this, and the circumstances for your particular organization will vary. So some of this information may be relevant to you and some may not. So please seek further advice when thinking about setting up your company. But thank you for taking the time to watch this presentation from the AYCH Creative Entrepreneurs Business Incubation Program. Please join me for the next in the series. Goodbye.